Okay, why don't we get started? Hi all, and welcome to today's housing updates from Washington. Now, normally these are NAHRO's bi-weekly half-hour opportunities for you to hear directly from staff about what we're specifically focusing on throughout the year. But today we have a special webinar planned for all of you. It is jointly hosted by our friends at the following organizations: PHADA, the Public Housing Authorities Directors Association; CLPHA, the Council of Large Public Housing Authorities; NILC, the National Immigration Law Center; NLIHC, the National Low Income Housing Center. And we're so happy to work collaboratively with all of you. It's always a pleasure to work collaboratively with all of these great organizations. And of course, we are NAHRO, the National Association of Housing and Redevelopment Officials. My name is Tushar Gurjal. I'm a Senior Policy Manager here at NAHRO, and I'd like to welcome you all to today's session on behalf of Mark Thiele, NAHRO CEO, and Eric Oberdorfer, NAHRO's Director of Policy and Legislative Affairs. By registering for today's session, you are also registered for all of our 2025 sessions moving forward. We hope that you continue to join us throughout the year. But before we get started, I do have a couple of housekeeping notes for all of you. So today's session will have a Q&A feature for attendees to use. Please insert your questions into that feature, and our presenters will try to answer as many questions as they can after their presentations are done towards the end of the session. Additionally, we will have 3 quick polls at the end to receive your feedback on today's session. These polls really help us improve and refine our sessions, so we strongly encourage you to answer them. Okay, that's it for me. I'm going to pass it on to Sunya Zaderman, the CEO of CLPHA. Sunya?
Thank you, Tushar. I'm Sunya Zaderman, the Executive Director of the Council of Large Public Housing Authorities. I want to welcome all the CLPHA members that are on this call and thank my colleagues at the other organizations for working collaboratively to pull this together. This is a challenging time that we're facing, and there is a focus on and attention on legal analysis, on increasing our knowledge base about how to effectively respond. And we're working collaboratively, not only inside our organizations, but with all the hosts that you see here. I want to emphasize how important it is for us to support frontline workers, because they will be the first contact in a lot of cases in these issues, and with many challenges. So we hope this will be useful to you, and we have feedback on what is going to help you navigate this. Thank you to my colleagues, and look forward to the webinar. Thanks.
Hi, good afternoon, everyone. I'm Julie Piccolo, a Senior Policy Analyst with PHADA. And today I would like to extend a warm welcome to PHADA members joining us today, and to thank you for the incredible work that you're doing each day. Today's webinar is an important opportunity to gain some practical insights on the topic that really matters to you. And we're appreciative of our 3 panelists for taking time to share their expertise with us today. We have Heidi Altman, Vice President of Policy at the National Immigration Law Center. We have Keith J. Harrison, who is a partner at Crowell Moring, LLP. We also have Lauren D. Song, Lead Attorney of Community and Public Initiatives at Greater Boston Legal Services, formerly Senior Attorney, Federal Assisted Housing at the National Housing Law Project. Without further ado, we'll let the presenters get started.
Great. Hi, everyone. And I believe I am kicking us off here. My name is Heidi Altman, and as you already heard, I work at the National Immigration Law Center. I use she, her pronouns. I'm really grateful to be here today. I'm grateful to all of you for being here and attending and listening in, and grateful that this is the topic that there's this much interest in hearing about. My agenda for the next 9 or 10 minutes or so is to give a bit of an orientation of the really massive and sweeping change in the government's approach to immigration law and policy that we've seen just in the past month. and to zoom in a little bit on the policy, not a little bit, a lot of it on the policy changes that will impact folks who live in public housing and those of you who are here today. And then I'm going to hand it over to my colleagues who are going to orient you a little bit more to some more specific action items. So starting with the first slide, I'm going to begin with a focus on, well, let me put it this way. I could give probably like a 3 to 5 hour webinar just on the policy changes that the Trump administration has put out in its first month in office. So I'm going to give a high level overview here and then narrow in on a few of the specific changes that are most relevant to our conversation. This is a very, very frightening and dark moment for a lot of marginalized communities in the United States, but especially for immigrant communities. And just to put a fine point on that, I will flag an issue that is at the front of our minds right now, just in the past 12 hours, which is that the Trump administration has announced a registry requirement for most undocumented people who have not otherwise already come forward and given their fingerprints to the government. And the administration is not being shy about the fact that they are asking people to come forward so they can target them for criminalization, prosecution, and deportation. It is a very scary moment. So it started with a series of 9 executive orders that were issued by the Trump administration literally on day one, right, the day of inauguration. These executive orders did many, many things, and this slide gives a sense of them. One of them was that it really sort of blew the lid off of the restrictions that we have gotten used to in terms of who the government actors are who are engaged in immigration enforcement. So the executive orders made clear that this administration is going to be using military bases, bringing in active duty troops, considering agencies like the DEA, like the FBI, and even the IRS to sort of supplement and engage every part of the federal law enforcement apparatus in immigration enforcement. We can go ahead to the next slide. Those day one executive orders were followed very, very quickly by a series of memos and other specific policy actions from the federal agencies that engage in immigration enforcement. So, for example, the executive orders called for dramatically ramped up immigration enforcement writ large. And very shortly after the issuance of the executive orders, we started hearing that ICE had, for example, put a quota on the number of arrests that individual immigration and customs enforcement field offices were required or expected to report every day. The administration also moved very, very quickly to pull away protections from communities who had received new and somewhat innovative legal protections under the Biden administration. So I'll just highlight a couple of those here. Many of you may be familiar with the temporary protected status, which is a type of, as the name suggests, temporary status that includes protection from deportation and employment authorization for people who are already in the United States but couldn't return to their country of origin because there is a countrywide crisis there that might be a natural disaster, could be widespread political instability, et cetera. The Biden administration had continued temporary protected status for individuals from many nationalities. And actually, I'm realizing that these slides, which I just made a couple days ago, are already out of date because the Trump administration has already pulled back temporary protected status for not just nationals of Venezuela, but also nationals of Haiti. The administration is also moving to end programs and protections for people who came from 4 countries, specifically Cuba, Haiti, Nicaragua, and Venezuela, who came to the United States during the Biden administration on a particular program, often referred to just as the CHNV program for the names of those countries, but that allowed people to enter on parole, which is the lawful permission to enter And the administration is moving quickly to try to end those protections, in addition to stopping the use of the program to allow individuals to enter anew. So we can move to the next slide. Generally speaking, as I already mentioned, this kind of rescission of protections is being paired with a dramatic uptick in arrests, raids in communities, and deportations. Many of you are hearing a lot of rhetoric from the administration about how they're going after the quote unquote worst of the worst. And we really need to have our eyes wide open to the fact that that is a part of a larger dehumanizing and criminalization campaign by this administration. The fact of the matter is that the vast, vast, vast majority of those who are being arrested and subject to raids have never had involvement with the criminal legal system. One of the things that the administration is doing very quickly is moving to strip away due process protections for people who are taken in through these raids and enforcement actions. One of the ways they've done that is to expand a fast-track deportation process, the technical term for which is expedited removal. And basically what this means is that when DHS or ICE encounters someone anywhere in the United States and arrests them, they can very quickly move to detain and deport them within a matter of days without ever seeing an immigration judge. This process applies to people who have been in the United States for less than 2 years. So in a lot of the Know Your Rights materials you're going to hear from us today, you'll hear reference to the importance of people preparing themselves by gathering and carrying with them proof of having been in the United States for 2 years. It's not protection against deportation in and of itself, but it should be protection against being put in this fast-track deportation process, and at least being able to see an immigration judge prior to deportation. Moving on to the next slide. So I want to spend a minute, because it's very relevant to all of us today, to talk about another change that accompanied these early actions in the first week or two of the administration. So for decades now, there's been a policy in place across administrations wherein ICE limits its enforcement actions at certain locations that are sensitive or protected. These are locations that are really critical to all of our community's well-being. Places where it's important for people to feel safe, like healthcare facilities, churches, and other places of worship, schools, social service establishments such as domestic violence shelters and homeless shelters, and emergency response sites. One of the first things that the Trump administration did was to rescind the memo that limits ICE's ability to engage in enforcement actions in these locations. So if we can move to the next slide. Where all of that leaves us is that we still have the US Constitution and we still have other laws in place that do provide protections to everyone in the United States, regardless of their immigration status or their place of birth. And it's incumbent on all of us to understand what those rights are, whether or not we ourselves may be impacted, but so that we can protect those who live in a particular public housing facility or who are our neighbors or whatever the case may be, right? So I'm going to click through a few of the rights, the constitutional rights that remain no matter who is president. And we put this slide right after the sensitive location slide, right? Because we're having these same conversations, for example, with school administrators and with administrators of healthcare facilities who were used to having an extra layer of protection against immigration enforcement, and now are needing to really refresh and remind all of ourselves on these rights. So these are rights that individuals have under the Fourth Amendment. And basically, the first right we have outlined here is the right to refuse entry into a home. And this is pretty simple, right? If someone is in their own private space, And that private space could be a home, but it could also be an office, or it could be any other space that any member of the public would not reasonably expect to have free entry into, right? So in a private space like a home, ICE and any other enforcement agency working with them does not have the right to enter unless they have been given consent or they have a proper judicial warrant. And so, you know, this is hard, but we are working closely with community members to encourage them to practice. If you hear a knock on the door, do not open the door, but yell through the door. Are you here with immigration? And I do not consent to let you in. Do you have a warrant? If you do, please slip it under the door. And then training folks on what to look through with a warrant. One thing I'll note about warrants is that immigration officers often have what they call administrative warrants with them, which, will have, an ICE officer signing it. That is not a judicial warrant. That does not give that is not sufficient lawfully for ICE or another immigration agent to enter. It must be a judicial warrant. The right to remain silent becomes critical, and the right to speak with a lawyer becomes critical. We'll click on to the next slide. Preparation. So we are doing a lot of work with communities about the necessary work of planning and preparing and being ready in case there is an immigration action. Individuals do need to carry lawfully their lawful permanent resident card or green card or valid work permit if they have one. Getting ready and preparing the proof of 2+ years residence. And that's something that may be relevant to all of you because people may be coming to you asking for help in finding a document. It really can be any reasonable document that shows that they've lived at a US-based address for the past 2 years. And creating a safety plan, because unfortunately, mixed status families are facing the very real risk of being taken away from their children and loved ones who they care for. We can move to the next slide. Communities protect each other. I'm gonna use this slide as a segue to our next speaker, who I think is Lauren, but it's not. To our next speaker, Lauren's telling me it's not. But just to if I can give a little bit of a call to action here, we have seen that knowing your rights, it's powerful. We have heard that immigration actions are reaching fewer people, especially beloved members of our community, because people are understanding the rights that they have, and because US citizens who work with and in communities like you all do that include mixed status families are encouraging people to stand up and providing safety and protection and providing information and know your rights cards and helping people get the evidence that they need to show those 2-year status and working with people to create written plans. This is powerful. It will limit the ways in which our communities are disrupted and families are upended by the enforcement actions these agencies are undertaking. So I'm sure there'll be Q&As at the end, but I'm going to close there for the moment and hand it over to our next speaker. And it's Keith, of course. Thanks, Keith.
Thank you, Heidi. That was a great lead, and I appreciate it. My name is Keith Harrison. I'm a partner with the law firm of Crowell Moring. I'm based in the Washington, D.C. office. I'm in the litigation practice group, but I'm also the chair of our pro bono community service program. Probably most relevant here is I began the practice of law as an assistant district attorney in Manhattan, New York, where I got a crash course in the Fourth Amendment and what law enforcement can and cannot do in terms of coming into people's homes. So from that background, we want to talk about what to do before, during, and after ICE enforcement. So I'm going to run through this pretty quickly. There will be time at the end for questions, but because time is short, I'm going to try to move fast. Okay, next slide, please. All right, now before enforcement action, one of the things that I want to say just generally is with regard to frontline workers, staff at the housing complexes, take the time to try and give them some training, some idea of what to expect. And this is going to be critically important, and we have some suggestions. But one of the things you can do, as Heidi was saying, is to make sure that areas are designated spaces that are off limits to the public. So if there are, where things are private, put up some signs to indicate that. Now, on the one hand, you might say, well, everybody knows that, there are certain places within housing units that are going to be private. Yes, no question. But this is more of deterrence. It's just like putting up a no trespassing sign. People know that it's probably private property, but the no trespassing sign kind of reinforces it. So think of signage that reinforces essentially the Fourth Amendment rights of the folks who are staying in the public housing units. Okay, establish a supervisor on call protocol so that frontline folks, staff people know who to call when, stuff happens, when, ICE shows up or people start knocking on doors. Remind them of the Privacy Act and other limitations with regard to sharing confidential information and documents. Now, that's kind of beyond the scope of our call today, but certainly you can reach out to pro bono legal counsel in your community and other organizations to try to get some more information in that regard. Instruct staff on how to request government warrants and the difference between a judicial warrant and an immigration warrant. I'm going to jump to that in just a moment and give you a little more details of that. But in any event, you want to make sure your staff knows the difference. Finally, there are Know Your Rights materials. We're going to go over some examples. They are available online in various locations, but this enables your staff not to try to pretend to be lawyers. Generally speaking, you really don't want your frontline people playing lawyer. But if you put up Know Your Rights materials, preferably translated into the language of your communities, that will help educate people, as Heidi was saying, about what their rights are in circumstances when they're confronted with ICE agents. There are ICE guidelines, ICE guidance, which our law firm and other law firms have prepared. I believe they're going to be available as part of this presentation. But take some time to look on the internet. There's a lot of sources for that sort of guidance. Next slide, please. So now that's well, let's see. This is just an example of a Know Your Rights type of poster, as I was just referring to, that you can, put up in places where folks in your communities can see them. And then there's an example of a family safety planning toolkit. Again, as Heidi mentioned, because, there are people need to be prepared for situations in which families may actually be frankly torn apart, and there need to be contingency plans for children who are allowed to stay when their parents are potentially taken into custody. Next slide, please. Now let's talk about during an enforcement action. ICE shows up at your housing project. This is aimed at your staff, your frontline workers, and this is why training is so important. The most important thing, and the first thing, is to stay calm, be professional, and respectful. I understand it's a lot easier to say than do, but if you go through some training and even maybe some role playing, that will help your frontline staff be prepared because they just haven't, this is not something that happens every day. First thing they want to do is calmly request and record off the agency, names, and badge numbers. Now, why did I say the agency? One of the things that can happen during an ICE raid is ICE agents can wear safety equipment that says police They are not police. There are legal differences between what police can do and are able to do and what ICE agents are able to do. Being able to recognize those differences and document them is important. The next thing they need to do is notify a supervisor. And we talked about having a protocol for that. Next, they should inform the ICE officers, or even if they're police officers, that they do not have consent to enter any residences. Okay, the Fourth Amendment so far is still being upheld by the courts, and whether they're police or ICE agents, they do not have the authority or the authorization to enter into a resident or any other area where someone has a reasonable expectation of privacy without a warrant. So that means that your frontline staff, if the ICE agents say they have a warrant, you have a right to see it. So request to see the warrant and then check whether it's a judicial warrant or an administrative warrant. And we're going to get to explain, I'm going to explain that in more detail in just a moment. Now, during the ICE raid, what should frontline staff be doing? Okay, it's okay to remind them that, they can remind residents that they have a right to remain silent and a right to speak to a lawyer. There's one exception to that right to remain silent. If they have immigration papers on them, they are required to show those. So if ICE agents ask them for their immigration papers, they cannot refuse to show them. They have to show them. Again, this is something that would be on the Know Your Rights type of poster that you might put up. That's why, I think we put staff in a difficult position if we're asking them to play lawyer during an ICE raid. They may make a mistake, and they may put themselves in harm's way. It is okay to to videotape enforcement action. So you can use your phone, but the important thing is not to interfere or assist, or not to interfere, or there's no requirement that your frontline staff assist, with the raid. So they don't have to identify people, or if the ICE agents ask for a particular individual, they don't have to, they should not call that individual to report to the front desk or something like that. In fact, your staff has the right, just as every other person in this country does, not to answer questions. They can just, say, "I'm sorry, we're not allowed by policy to answer your questions." And they certainly should, and we'll talk about this in terms of post-raid processes, contact local immigration rights organizations. Next slide, please. Okay, we talked about the difference between a judicial warrant and administrative immigration warrant. They look different. A judicial warrant is issued by a court and is signed by a judge. Those are the key differentials. You're going to want to look for your staff is going to want to look for that it came from a United States court and that it was signed by a judge or a magistrate. The judicial warrant is also, if it's a search warrant, it's going to have the address of the location to be searched. This is really important in terms of public housing because it's going to, specify where they can search, which means that every place else they can't search. So you're going to want to read, the search warrant, your staff is, and then if ICE agents start to search places that aren't identified in a judicial warrant, staff should inform them that's not the location that's in the warrant, but that's it. They shouldn't interfere. They shouldn't do anything, especially not try to touch or intercede with ICE or police officer. Now, on the right, you have a administrative immigration warrant. It comes from Homeland Security. This is an example. It's going to be signed by an immigration officer. It does not allow the search of any private property. So if ICE shows up with one of these warrants, an administrative warrant, they can't enter a residence. They can't search some area that is designated as private, okay? It's very important. It would be great if our ICE agents complied with the Constitution and did not try to use administrative warrants, beyond their scope, but they do, unfortunately. Next slide, please. Okay, this is just kind of a more of an example of a search warrant. Again, this has a little more detail. I believe these materials are going to be shared, so you can go through these and educate yourself and use them to educate your staff as well. Next slide, please. Okay, after the ICE leave the premises. Now, unfortunately, that's not the end of the responsibilities, because you're going to want to document as much as possible what just happened. The date and time, location, how many agents, which agencies. So in some states, the police are going to show up with the ICE agents, and they're working together. So, try to have that information. What badges did they have? This identifies, a list of information that would be useful after the fact. Why would it be useful? Lawyers for someone who might have been taken away, might be able to use this information to aid some of the residents in terms of their immigration proceedings. An important thing is who was removed. If people were removed and you know who they were, that information is going to be helpful in terms of notifying next of kin or other folks that, someone was taken by the ICE agents. Next slide. That may be my last slide, but yep, that's my last slide. Sorry for going through that so quickly, but now I'm going to hand it over to, is this Lauren I'm handing over to?
Next slide, please. How am I doing on time? I know that got kind of a little bit of late start, so I just want to know how quickly I should be doing my piece. Next slide, please. Okay, so just very, very quickly, my name is Lauren Song, and I'm a lead attorney with Greater Boston Legal Services, and my primary work is in community and public initiatives. So until very recently, I was a senior attorney with the National Housing Law Project, where I focused on policies to preserve federally assisted housing, working primarily with HUD. And during my decades of housing work, I have had the honor of collaborating with many PHAs, both large and small, and bringing them together with the residents and local legal and organizing advocates, especially as they were navigating together the very complex redevelopment of sometimes very distressed public housing buildings. Today, with only about 1 month of the new administration behind us, I feel like I could be really, really disoriented, and I'm sure many of us feel the same way, which is the intent. But in fact, I'm very fortunate to be grounded to be a part of this national team, and you, members of NAHRO, CLPHA, and PHADA, and other affordable housing stakeholders, which is meeting regularly on your behalf. As Sonia said, working together, I know that we can and will continue to provide rapid response events like today's webinar, as well as develop long-term strategies to sustain and preserve HUD-assisted housing communities and to protect our residents. Even as the news remains pretty dominated by another budget reconciliation process and we face yet another potential government shutdown, NAHRO, CLPHA, PHADA, the National Low Income Housing Coalition, and my former organization, National Housing Law Project, are all collaborating together to keep a very close eye on the budget and the appropriation processes for not only this coming fiscal year, but the last one, which has not yet been finished. And perhaps most urgently, we're working together on strategies to mitigate the threatened loss of about 50% of the HUD staff in the very near future, which will have very profound effects on our ability to continue our work. And also, for those of you who may be waiting for GRRP funds to continue your housing rehabilitation work, which Dodge has suspended, we're hoping that somehow we can figure out a way to liberate those funds which have been suspended. I also want to appreciate, as Julie and Tushar did at the beginning, the critical and important work of each of the PHA leaders and staff, especially all of you guys here today who thought that this was an important enough topic to spend your time, and other housing providers to make this collective goal possible. So thank you. And in the meantime, while things appear like there have been seismic shifts at the federal level with the new administration, it's really important to remember that as to our day-to-day work with our residents and applicants, nothing has changed. And we must stay the course in terms of providing safe and secure homes for all of our residents and our communities. First, no matter how much militarization and weaponization, the immigration enforcement system and process is still a civil process, and it needs to comply with the judicial order requirements that was mentioned earlier by both panelists. And they must produce, judicial orders if they're going to do any entry into homes, search and seizures of locations or documents or requests for documents. Then this is beyond, what they're authorized to do under the immigration, which is to detain and arrest non-citizen for immigration-related violations. I just wanted to, make that distinction really, really clear. And second, the lawful immigration enforcement procedures at residential communities like the ones that we're talking about here continue to be subject to all of the existing federal and state privacy rights and constitutional rights that applicants and residents of HUD-assisted housing have, and they've always had. And other private individuals have with respect to their homes. So unlike the sensitive locations that Heidi mentioned, which enjoyed a layer of additional protection from immigration enforcement under what was just basically Department of Homeland Security policy, the privacy rights and that residents and applicants have with respect to their homes is guaranteed by the Constitution, right? And those cannot be changed by any executive order or action. So they are in place, and we need to continue to comply with them as housing providers. Those are our obligations, and those have not changed. Third, the HUD-assisted housing providers are subject to an additional layer of due process and legal protections, which I'm sure you guys are all very familiar with and aware of, with respect to handling private information and documents, as well as under the Fair Housing Act and other civil rights laws, which prohibit discrimination, including on the basis of national origin. So none of those things have changed, regardless of what executive orders have been announced about DEIA and other things. These are all the federal laws as well as the state laws that we must continue to comply with respect to our administration of our obligations as housing providers, as subject to these federal regulations and laws. And this includes with respect to any eligibility determination and screening processes. I know that during the COVID, PHA suffered a great loss of staff and turnover in staff. So it may be that it's an important time, and it hasn't been that long that since we've just come out of that very difficult and challenging time. I'm sure you guys all remember. But it may be that we can all benefit from a refresher, more training that covers basically what the eligibility and screening processes require, especially with HOTMA changes that have come around, which even though not yet in forms, there's just been a lot of changes that have been going on. But in particular, with regard to the one-time only disclosure requirement with respect to Social Security numbers and verifications, which only apply to people who are contending that they are eligible for the rental assistance. For those household members who are not contending that they're eligible, those do not need to be verified. And also with respect to the U.S. citizenship declaration and verification of the immigration status of those members who declare that they are eligible through the SAVE, which is the Systemic Alien Verification for Entitlement process system. And that these are subject to a CIS appeal process. And also that the only required background screening is with respect to the lifetime sex offenders using the National Sex Offender Database. And this is why it may be that if there is ICE enforcement action that has been experienced in the past, and people, there's a lot more publicity now about like, oh, this has happened, et cetera, especially under the quota that that Heidi mentioned. But the reality is that I think the numbers have not changed significantly from before and now with regard to individual ICE enforcements. These are not the raids that seem to be happening. And this is important to recognize because we really don't want to alarm our residential communities beyond the fear that they're already feeling. So everything with regard to respecting their privacy rights, the normalcy is really, really important to preserve, but to provide that added layer of protection by providing the signage that declares where the private areas end, especially in reception areas, those are all very helpful. But a refresher course for staff about what the proper procedures are, especially with respect to calculating expected rents in mixed families, where some members are contending eligibility for assistance, whereas others are not, and which ones are subject to the EIV, income, verification searches, et cetera. So some of those documentation requirements may become confusing to residents, and in the mix with all of the focus on immigrants, et cetera, staff may become confused and demand more documentation and verification than is necessary. So it's a good time to remember all of that. All of this is to say, again, a reminder that despite the enormous amount of activity and noise and constant news we're covered with, for our obligations as housing providers under federal assistance, under federal laws that govern privacy, et cetera, these privacy rights and appeal procedures are all still in place. And our staff just needs to be really reminded that we need to comply with those things, and that our obligation is to provide a safe and secure home for our residents and make sure that the applicant process is done fairly according to the Fair Housing Act. So I just want to quickly close by saying that I too am very, very grateful for all of NAHRO, CLPHA, and PHADA members and leadership coming together, and my co-panelists, their generous time coming to give these presentations and giving their expertise in sharing this information. And I know that working together, we will be able to get through this together and be all that much stronger as a result. And this is a great opportunity for us to continue to do that. So thank you again for attending today. And now I turn this over to folks who are going to be facilitating Q&A discussion section.
Excellent. Thank you so much, Heidi, Keith, and Lauren, for helping us understand PHA staff's roles and responsibilities. Let's turn to the Q&A section of our presentation. I'm going to turn it over to our PHADA and CLPHA friends, Julie and Madeline. Are there any questions for our presenters?
Hi, there was a question for Heidi on the Know Your Rights screen, the map with the red and green, just looking for some clarification on those differentiations.
Thanks, Julie. I saw that. I'm going to look back at the slides. I wasn't sure what that was referring to. So if you want to go to the next question, I'm not sure which red and green. So if we can go to the next question and then I come back at that, I'll look at the slides right now.
Sure, no problem. I think it was the one with the map, Heidi.
Okay, I'll take a look at
Heidi,
it.
it's the one where the states, there are some locations where there's an obligation, although you can remain silent, there's an obligation to identify, in some cases, your name, in some cases has to be your name and your address. So it's basically putting a qualifier on the, that it's not an absolute right to just kind of completely be silent in some of these states.
Thank you. And I think, and I won't take credit for it, I think this might be courtesy of Lauren, but we can drop the website that actually was the sourcing for that map.
It is in there. It is on that PowerPoint. So if we can share the PowerPoint, that PowerPoint has a link to the website that has been updating that.
Absolutely.
Great. Thank you, Heidi, and thank you, Lauren. The other question that came through was, what types of documentation do individuals need to have to prove 2 years of lawful residence?
Yes, I saw there were a couple questions on that theme. So that's a great question. There's no specific, guidelines that the government has put out that says what those are. So that means we can be creative. The rule of thumb is that people want to have evidence that includes their name, that shows their US-based address, and that has a sufficient set of dates on it to show that they have been continuously present. So ideally, you would want someone to have a few pieces of paper with them, one that shows that they were here, 6 months ago, one that shows they were here a year ago, 1 year and a half ago, and 1 3 years ago. And so we encourage people to bring mail that has the postmark date and their name and the address that they lived at. That's good evidence. Signed leases, very relevant to this conversation, can be helpful. Also things like school records and employment records. So anything that's going to have their name, their US-based address. Also, I think someone asked about whether like a register from your office that shows their dates of residence could be helpful. And the answer is absolutely yes, as long as it's clear, that it's from a sort of official document. That would all be very useful.
Great, thank you. I'll pass it over to Madeline for
Yeah.
some other questions.
I do have one question here in the Q&A, and it is it true that landlords and owners and PHAs are able to tell ICE they do not have permission to enter units without a judicial warrant?
Can I answer that? The answer is yes.
Okay, and on that note, if ICE were to come to a PHA and request information on a tenant, could they refuse to give that information up even if they have a warrant in their possession?
Yes. Yes. The warrant would not allow them, unless it was specifically identified as something, as a subject of a warrant, would not allow them to request documents and information that is maintained by the public housing unit. So, if they have a warrant to arrest someone or warrant to search an area, that warrant is specific to that individual if it's an arrest warrant, and to that area if it's a search warrant. So that would not allow either the police or the ICE agent, even if it's a judicial warrant, to obtain documents from the public housing service.
Okay, thank you. That's what I have.
Okay, well, Julie, Madeline, feel free to jump in, but we still have extra time and there's appear to be additional questions. So I'm just going to read off some of them. Quick question for Keith. Can you touch on how frontline staff should respond if ICE tells them to stop recording the incident?
Well, that's a great question, and always difficult situation. I don't know. Look, you can't anticipate what people are going to do. I think that most of the time, ICE agents and police officers, try to do the right thing. I don't think that if they asked you to stop recording and you didn't, that you would face any sort of potential harm, but you could. So, I'm not going to sit here and say that you should just disregard the police instruction. You would do so to a certain extent at your own risk. So, I think each individual is going to have to make a call. If I were in that situation, what I would do might be very different from what someone else, will do. So I can't really provide any advice. There's no reason that you should have to. So from a legal perspective, they don't have a right to tell you to stop, but, that's about all I can really say there.
Okay, thanks. I mean, if things are complicated, you should, let people know that things are complicated.
Right.
I'm just going to read out some of these other questions. Any thoughts on special considerations where tenants with disabilities may be in property where fear can cause spiraling and or there may be acting out, which is misconstrued by agents? a resident service coordination role. So if folks maybe have maybe a person with a disability, does that come into play in any way?
I
I'll
think,
take a shot at.
yeah,
Oh,
go ahead.
please.
No,
No,
go
please
ahead.
go ahead.
No, Keith, I want to hear what you have to say.
Okay. I would look, every fact situation, what's so difficult here is every fact situation is going to be different and unique, and you're going to have to use your best judgment. And there's a line between, you know, for example, interfering and trying to assist. So if someone were to act out, you know, because of a disability, and the police officers don't understand, you know, I think it would be appropriate to inform the officers of the disability, and, you know, just provide them the additional information that may enable them to handle the situation in a better way. But, you know, it's going to be a judgment call. But certainly if you can offer help in that situation, you know, that would be a reasonable thing to do, as long as you don't, you know, try to interfere with the officer or, you know, touch the officer. Lauren?
Yeah, I think you would not want to share more than you need to in terms of, you know, specifying what kind of disability is at play, et cetera. But whatever you can do to protect and making sure that the reasonable accommodation that the resident should be afforded, you know, is being there that can protect them. One other thing that question reminded me is something to be aware of is the fear that many residents have of collateral arrests, right? So it's not so much that so they've come with a warrant, like Keith said, that specifies this particular person's name and this particular address or location or property that they can be searching. And that's an official judicial warrant as opposed to like an ICE warrant. But they go and knock at the home, and instead the person who opens is a guest or some other person who is not named on there and is the person who gets arrested, right? So this is something that could happen. And I know that a lot of mixed families are very, very concerned about that. And they may have situations where there are children who are not aware that they are a mixed status family. And they have been warned not to, you know, do certain things. And if you see behavior that seems a little bit, you know, odd, it may be because there are additional concerns that that family has. I don't think housing providers should be invasive about asking, you know, what's going on in that situation if it's not being offered. But I think being sensitive to the fact that there can be other things like that at play is important to know. And that these protections also apply to applicants, right? They're not just the residents who are there. If someone is there at the housing property applying for something and they're in the private area applying with documents, et cetera, that is a private transaction. But having it clearly demarcated space-wise makes it more easily, you know, for the staff to say this is a private area, right? It doesn't put the entire onus on the staff who may themselves be scared of this unexpected situation to say, like, you know, no, you can't come in here. But the role play that I think that either Heidi or Keith mentioned is a really important thing to do, because, you know, the first time you do something, it just feels really awkward. But once you practice it, it's a much easier thing to do. And having a system of supervisors that they are supposed to call. And if they get a subpoena, remember, it's not about like you've got to open the door and like, you know, give them your computer, et cetera. You need to consult with your legal counsel about what the scope of that is, and making that chain of command really explicit. And the reason I mentioned the thing about new staffing is that maybe these are things that old staffing were familiar with during, like, you know, the past administration, but new staff may not have had that opportunity to have that training. I know that in my practice, that's been the case. You know, we've on-ramped a lot of new attorneys and they may not have had the same, you know, benefit of the same robust training that folks had. So this is a good time to assess whether this is, you know, an opportunity to do that properly.
Great, thank you so much. I'm going to ask you what looks to be a more policy-oriented question. So if you don't know, you don't know, but just thought I'd throw it out to you from folks. I'm hearing status may change for households receiving rental assistance benefits who are eligible non-citizens. Specifically, their eligibility for Section 8 public housing PBRA could be jeopardized. Are you able to speak to this? And that's for anyone who thinks they might, have.
That may be the case, and that is certainly was in play the last time around during the first administration under Trump. And it is certainly projected to be at play potentially under this. But remember that that is a legal process. It is not something that one does by executive action. And that has to go through the whole legal process of changing the eligibility, because currently the eligibility is set forth under federal laws as adopted by the particular agencies through proper rulemaking processes, et cetera. And if there is an attempt to shortcut that and kind of do it by unilateral pronouncement, I think there would be a legal challenge to the fact that this should have been something taken under a series of steps. But on a related matter, I will say that if there are cuts to benefits that mixed families rely on, for example, healthcare benefits or SNAP benefits, that itself could also affect, a resident household's ability to pay rent. And so we should be mindful and aware and supportive at a policy level that this is something that could affect all, regardless of immigration status or citizenship status, like all families who are relying on these could be majorly affected by policy changes on cuts on benefits that are being projected by the current reconciliation process.
Okay, let's see if we can sneak in. We're almost at time, so sneak in one more. While our offices are private, our board meetings are public. I presume you must allow ICE in, but are they allowed to conduct an investigation or question residents at the meeting to speak during public comment? Tough ones. We're throwing you a lot of tough.
I'm sorry, can you repeat the question about at which comment?
So housing agencies usually have like a
Public
board, a
comment.
governing
Yep.
board, and there's a public comment period. Can ICE agents question folks during those public comment periods residents who might be in attendance?
Maybe I'll talk to that. And I see that some of my colleagues from housing agencies are also on here and they may want to speak up. My understanding is that immigration agents can go into any place that is a public space, which is why it's so clearly important to mark places public and private. So if this was in fact a truly public community space, they too can attend that and make comments. But there are procedures even in those places for taking comments that are relevant to that public comment process versus that is not a space to pull out and name specific residents and identify them. But it is helpful to make sure that to make clear at those meetings that there are privacy considerations and people shouldn't be sharing their individual household situations at that public comment period. And there are also some public comment periods which are restricted to residents only that are not for the general public.
Okay, thank you so much, Heidi, Keith, and Lauren. And thank you all for attending today's session. Just so everyone knows, we are going to send slides to the attendees, so don't worry, you will be getting them. But before you leave, please answer these 3 questions, and I'm going to throw the polls up now. It is super important, just for us. It helps us know, are we on the right track? So that first poll should be up. And I will give it, let's say, 10 seconds. Maybe a little longer. It seems like a bunch of you are still answering. Okay, it seems like the answers, if you haven't answered, do it now. And I'm going to close the poll and let us launch our second poll. And that's how relevant was this session? And again, your answers help us determine how our future sessions will be structured. Give it, let's say, another 15 seconds. I know we're a minute over time, but I will get through this. We will get through this and let you all go back to the rest of your day. Okay, perfect. I am going to end this one, and we will launch our final poll. And that's, what did you think of today's session? I'll give it another 10 seconds. Okay, get your final answers in. I'm closing the poll. Okay, well, thank you all so much. Thank you to our presenters. Thank you to the other groups we're working with collaboratively. And thank you to all of you who came and listened. Have a great rest of your day, folks. Take care.